Hello everyone, this is Tom Fox and welcome to episode 21 of the FCPA Compliance and Ethics Report. We've had quite an interesting past couple of weeks in FCPA enforcement investigations, and in one case very public negotiations between a corporation and the U.S. government over the resolution of potential FCPA violations. So I thought it might be a good time to sum up and discuss what we've looked at or what's been made public over the past couple of weeks. Certainly wish Howard was here to share his views. I'm sure whatever they are, they would be very strong, but he's off in the corporate world now. So with that, the first enforcement action was the Diebold Corporation. And the Diebold Corporation settled with the Department of Justice and SEC for approximately $48 million. Unfortunately for Diebold, they were required to have a corporate monitor over the next 3 years to review their ongoing compliance efforts and their commitment to compliance and their commitment to fulfill the terms of the deferred prosecution agreement. One of the very interesting things about the Diebold enforcement action was that in large part it was based upon conduct which had occurred in China in the last decade. And the interesting thing was that this conduct had been investigated by Chinese regulatory authorities for potential violations of China domestic anti-corruption laws, and there was no enforcement action going forward. So here we have the rather anomalous situation that a domestic regulatory body investigated conduct, found no violation, and the U.S. Department of Justice investigated and found that it indeed violated the FCPA. So I think this is one of the first instances we've seen where a domestic regulatory body had investigated company for allegations of bribery and corruption, found no violations, and then the Department of Justice found violations under the FCPA. One of the other interesting things about the Diebold investigation was reported by the FCPA professor, and he quoted from a law firm report on the enforcement action. And I'm going to have to go to the glasses here because the print's pretty small, but I want to read from it first. And it comes from an FCPA update from Debevoise and Plimpton. And I'll just quote from this. The first noteworthy aspect of this resolution is the enforcement agency's decision to use the books and records and internal controls provisions as a vehicle for obtaining monetary relief, penalizing purely commercial bribery, 40% of the improper payments at issue. While not entirely novel or outside the theoretical reach of those provisions, were the enforcement agencies routinely to investigate issuers in connection with commercial bribery abroad, this risk-based calculus of almost all corporate compliance programs would potentially need to be rebalanced. Second, the total financial aspect of the resolution was 16 times the total value of alleged improper payments. In describing the improper payments, the enforcement agency aggregated a number of often small payments over 5 years. When considered along with the Ralph Lauren enforcement action earlier this year, the Diebold enforcement action, and particularly its imposition of a monitor, long considered one of the most burdensome aspects of FCPA settlements, could call into question one common view of statements relating to gifts and corrupt intent in the November 2012 DOJ-SEC Joint Resource Guide to the U.S. Foreign Corrupt Practices Act, namely that companies covered should not sweat the small stuff. The first point raised in the client alert about commercial bribery is the distinction that is not present in the UK Bribery Act, i.e. public bribery versus purely private or commercial bribery. However, the Department of Justice has brought cases under the Travel Act before, so while it may not be the norm or the usual, I don't find it to be that unusual that the department would put that in. But the thing that I would emphasize from this client update that is correct, or that I should certainly I agree with, is that companies need to change their decision-making calculus in this area. If a company has a compliance program mandating compliance with the U.S. Foreign Corrupt Practices Act, which prohibits bribery and corruption of foreign governmental officials, but allows commercial bribery, they may need to revisit this. Most companies have an internal prohibition on bribery, period, so that I think they would be covered by this. But if they don't or have that dichotomy, that may be something that they want to take a look at. The second point that I agree with as well, and I do find a little more troubling. One of the things that the Department of Justice has said in the FCPA guidance, and I think that they would tell you at the conferences they attend, is really exactly what was quoted. Don't sweat the small stuff. The smaller amounts will not be aggregated unless there's a clear pattern in practice or systemic failure of internal controls. By putting all of these together, the department may be suggesting that this really was systemic and it was an entire failure of internal controls. Nevertheless, I counsel clients on don't put a lot of your resources in the smaller risks, because they're not your major risk, and you need to deliver your resources where your risks are the greatest. And if it turns out that your risks are greatest on these smaller payments, you may need to indeed recalibrate your risk profile and your compliance regime to put resources in place to do that. I've seen companies do that. They have very low thresholds for gifts and entertainment. One company I'm aware of required Chief Compliance Officer approval for all gifts and entertainment. So I've seen those kinds of programs work, but that may be a message, or I would agree with the FCPA professor who has said on the record several times that he finds this to be a mixed message that the department is putting out. I would agree with that in the context of the Diebold enforcement action, that it's certainly a mixed signal. Next up is the Stryker enforcement action. The Stryker enforcement action was settled via SEC cease and desist order. In other words, it was a civil complaint, and it was not a deferred prosecution agreement or criminal enforcement action. Stryker was not required to have a corporate monitor, and Stryker paid a fine of about $13.2 million. Stryker had paid bribes in several different countries, but they had one bribery scheme that particularly struck me and I wanted to raise with you, because it may be something that you need to take a look at in the context of your FCPA compliance program. And that's, there was a charitable donation made to a Greek university, a public university of Greece. It was about, I think, $170,000 to $180,000, and the Securities and Exchange Commission cited this as an example of corruption, because there was a straight quid pro quo for the donation to obtain or retain a benefit going forward for Stryker. Previously, I had believed that a donation made directly to a foreign government was not covered by the FCPA. So if I could contrast it with the Wynn casinos, and Wynn in Macau made I believe, over $100 million donation to Macau University. Wynn received a declination from the SEC and the Department of Justice on this donation to Macau University, even in the face of the very large donation. I thought this was a clear signal that if the donation was made directly to a foreign government, they would take it out of the FCPA, or at least in terms of FCPA violations. Nevertheless, Stryker sustained a books and records violation and entered into a cease and desist order because of this donation to Greece, or in part because of this donation to Greece. It wasn't the only bribery scheme that they used. Perhaps it was misrecorded on the books and records. Nevertheless, if there are charitable donations you're making directly to foreign governments, if you're providing goods, services, products, something, you may need to take a look at that in terms of, is there a direct quid pro quo for the donation? So I thought that was an interesting aspect of the Stryker enforcement action. Once again, Stryker did not receive a deferred prosecution agreement, did not obtain any sort of criminal prosecution, and no monitor required. So kudos to Stryker for going forward and remediating during the pendency of their enforcement action. The Department of Justice, the Securities and Exchange Commission went into some detail on the actions that Stryker took, and I would invite you to review those and read those to see if there are any remedial actions that you might need to take on in your program that Stryker took to raise it up to a level where they did not have a criminal enforcement action. Well, we've had several other interesting announcements over the past couple of weeks that I would like to go over. The first one was the Brazilian company Embraer. They're an airplane manufacturer, and they previously noted that they were under investigation for potential FCPA violations. Information came out that there's an allegation of a $30+ million bribe paid to an official in the Dominican Republic to obtain a contract for the sale of airplanes into that country. So we have some specificity around the potential allegation of bribery and corruption. But perhaps the more interesting thing about Embraer is that the Brazilian regulatory regulators are now looking into the company for internal violations or violations of Brazilian domestic anti-bribery and anti-corruption laws. These would be laws that would, much like the FCPA, focus on foreign governmental officials, meaning foreign to Brazil, so it's not strictly a violation of domestic anti-bribery or anti-corruption laws in Brazil. And this is really the first time we've seen this type of cooperation between the U.S. FCPA regulators, i.e. the Department of Justice and SEC, and Brazilian anti-corruption regulators, or at least this is the first public knowledge, public announcement we have of this. With Brazil's passage of an strong anti-corruption law last summer, coupled with the ongoing debate and dialogue in that country regarding bribery and corruption and street protests, the upcoming Olympics, the upcoming World Cup, it's all thrown into a very interesting mix that I think companies who are doing business in Brazil and any Brazilian companies will need to take a look at very closely. I can cite you to Matt Ellis, FCPA America's blog, for really probably, in my opinion, the country's top anti-corruption expert for Brazilian matters. He writes on all matters of anti-corruption and anti-bribery in Latin America, Brazil, Argentina, you name it. He speaks both Spanish and Portuguese fluently. He does a blog that is published in both English, Portuguese, and Spanish. So if you are a Brazilian listener to this podcast and you would like something a little bit more in your native language, I would invite you to go to the FCPA America's blog, and Matt Ellis can help you with some of your questions that you might have. But a very interesting development in the Embraer FCPA anti-corruption investigation. Next up is Weatherford, and Weatherford is a Houston-based energy service company. They've had a very long road, long journey in an FCPA investigation, and it appears that journey is nearing its end. There was an announcement in the Wall Street Journal today that Weatherford, I believe, was reserving between $225 and $250 million for settlement of outstanding FCPA violations, and perhaps some export or other violations as well. Nevertheless, this is certainly welcome news to Weatherford. It's been a long road to hoe. They have taken extraordinary steps to increase their compliance function within the company. They hired a really top FCPA white-collar defense practitioner named Billy Jacobson to be their chief compliance officer, and he has put together a best-in-class energy service company compliance program. If you've ever heard any of the Weatherford folks speak at conferences, you know of their commitment to compliance, you know of the company's commitment to compliance, and you know that they worked very hard to resolve or remediate the hole that they were in for their prior FCPA, at least allegations that perhaps the specific violations will come to light. We do not know yet whether Weatherford will have a corporate monitor or not, nor have we seen any of the resolution documents, so I can't really comment on those. Perhaps at a later date I can do that. Nevertheless, welcome news for Weatherford, one of the very large and lengthy matters that has been ongoing for some time. So a welcome settlement for everyone. Which brings us to our friends at Avon. Avon has been under FCPA investigation since they self-disclosed potential violations of the FCPA in China back in 2008. Avon has been the poster child for investigative expenses and related costs during the pendency of the FCPA investigation. Since 2008, they've rolled up, I think, in the range of $300 million in investigative costs and other costs related to their FCPA journey. They have had, it's been reported that the Department of Justice has went to a grand jury over some potential criminal allegations against the company and or its officers and directors. So very serious matters. But what is interesting is apparently Avon is now in the throes of negotiating with our U.S. regulators, both the Securities and Exchange Commission and the Department of Justice. But what takes this to the most interesting is that Avon has decided to do this publicly. And they've done it publicly in the following manner. In securities filings in June, they announced that they had made a $12 million offer to the Securities and Exchange Commission, which was rejected. In a securities filing last week, they announced that the Securities and Exchange Commission had come back with a proposed fine, which Avon did not believe was warranted. We really haven't had public negotiations like this before. I can't imagine this would lead to anything positive for Avon. The commentariat posed questions that Avon could sustain fines and penalties both from the Securities and Exchange Commission and the Department of Justice as high as $750 million. I find that not to be credible because that would be the largest FCPA fine against a U.S. company. Siemens is $800 million, but they're a German company. I don't think that what we know today would warrant a fine of such an amount. Nevertheless, Avon has disclosed that should the fines of the proposed fines of the Department of Justice and SEC be required, the company be required to pay them, it would materially affect the company's cash flow and their business position. Very unusual for a company to say that. I have not negotiated with the government on FCPA fines. My colleague Stephen Martin has, and he has a great story he tells. If you've ever heard him speak, I would ask you to tell him the story about negotiating with the government over the Adelphia fine and penalty. Nevertheless, I believe that negotiating in public is not the stance to take with U.S. government regulators, whether they be the Department of Justice or the Securities and Exchange Commission. I think that that should be a private matter between the parties. I don't understand why Avon might be doing this. Nevertheless, they've obviously made the decision to do so. We will just have to see how it plays out. But very interesting, something we don't typically see. One investigation I would have to know, just because it's so unique, is National Geographic. Yes, the television channel, the magazine, the photographs, the reclamation of artifacts, the everything that National Geographic stands for. Unfortunately, they are now under a potential an FCPA violation for allegations of payments to an Egyptian governmental officials to receive access to Egyptian artifacts, not for nefarious purposes, but for the kinds of things that National Geographic is known for. One of the first public announcements of a investigation against a charitable organization, so we will have to see where that leads to. But National Geographic, I think everyone certainly my age remembers the magazines. We certainly remember the maps, now the television channel, and now they're under potential FCPA scrutiny. The last one is our friends at J.P. Morgan Chase, and this is the ongoing investigation from their Sons and Daughters hiring program, where they had a hiring program set up to bring in sons and daughters of Chinese governmental officials. Unfortunately, there is information that may lead to the conclusion, or at least allegations, that these sons and daughters of Chinese governmental officials were hired to curry favor with their parents, their father, who was either a Chinese governmental official or officer or director of a state-owned enterprise, and that these hirings were tied to specific contracts that were awarded to J.P. Morgan Chase. This investigation is ongoing, but apparently now it's spread to several other countries in the area in Southeast Asia, so the dreaded where else question has been raised. I wrote about this earlier this week, and the where else question means if you have a systemic failure in internal controls or your controls in one country, The Department of Justice will generally want to know if you have that same systemic failure in other areas. If controls are evaded in one place, is there a possibility, probability, or reality that controls are evaded in other locations? This is one of the reasons that FCPA investigative costs can certainly explode. We saw that with HP and their allegations of bribery out of their German subsidiary. The investigation expanded into Central Europe and into Russia and perhaps other locations. Walmart also is an example where the allegations initially in Mexico and then spread to Brazil, Russia, India, other locations where Walmart had stores. So the dreaded where else question has been posed to JP Morgan Chase on their hiring of sons and daughters of foreign governmental officials, or family members probably is more accurate. So very interesting to see where this may go. Like I said, it's been quite the past couple of weeks. I've written about all of these topics on my blog site, the FCPA Compliance and Ethics blog. If you would like a little bit different take and certainly a much more legal perspective, I would invite you to visit the FCPA Professor. And then if you want to keep up with current events, I would urge you to follow the FCPA blog. They're usually the first and the fastest to get you information about what's going on. Also, Corruption Currents blog site on the Wall Street Journal, Governance and Risk blog site. Sam Rubenfeld does a daily wrap-up of all things compliance. It's broader than FCPA. It includes money laundering, export control, general corruption, an excellent resource for you to refer to on a daily basis. My name is Tom Fox. If you have any questions about anything I've raised, you can reach me via email at tfox@tfoxlaw.com. That's tfox@tfoxlaw.com. I hope you found this helpful and look forward to visiting with you at our next episode. Thank you.